and welcome to our Prestige PEO webinar series. My name is Shannon Shaw. I am Operations Supervisor at Prestige PEO and your host this morning. Today, we will be talking about compliance updates in the Northeast region. I'm joined by Elizabeth Shaw, VP General Counsel, and Megan Siegel, Corporate Counsel. Our webinar viewers are automatically muted, but we encourage you to utilize the chat feature for any questions you may have, and we will address them at the end of the webinar if time allows. If your question is not answered, we will follow up with you shortly after the webinar concludes. The webinar is also being recorded and will be posted on prestigepeo.com/webinars page so that you can refer to it at any time. And now we'll get started with the webinar. Welcome, Liz and Megan.
Good morning. Welcome, everyone. Hi, Megan. Thank you for joining me today on our webinar. We are super excited to be here to be sharing about some updates for the coming year and some trends to keep an eye on. So we are ready to dive into it. Megan, are you ready?
I am. Let's go.
All right, excellent. Well, our agenda for today is we are first going to talk about federal employment law updates. Then we're going to go over some case law that should at least be on your radar as out there so you understand the impact it may have on your business. Then we're going to go over some state-specific updates for our Northeast states and just kind of highlight some of the important ones that we've seen that we think you should be aware of. And then we're going to talk about some employment law trends and hot topics for 2024. Our webinar today is not intended to be legal advice, even though Megan and I are attorneys, but it is definitely for informational purposes as you try to be the best employer that you can be with the ever-changing political climate that's out there and the impacts that that can have on business, and as the employment landscape continues to change. So let's dive into it. And first, we're going to talk about some federal employment law updates that we've seen that you should be aware of. So I'm going to start us off today, but Megan and I are going to kind of trade off. I might interrupt her from time to time to highlight some things. She might interrupt me, but we're going to have a really great time going through these things this morning. So the first thing that we want you to be aware of is that the U.S. Department of Labor has issued an updated overtime rule. The prior rule was introduced in 2019. It went into effect in early 2020. But last August, the U.S. Department of Labor came out and they said, okay, we're going to do a new updated rule. And they've been doing this over the past several years because they are trying to adjust for, changes in various things like inflation, cost of living, all of those things to make sure that, the salary thresholds that are out there really are appropriate for the workplace. And so they came out with this new rule where they want to change that overtime exemption threshold where you no longer are required to pay overtime to certain employees from $35,568 a year to $55,068. So that is a pretty substantial increase, and it is possible that there will be some pushback and litigation over, the coming months as this heads towards going into effect. That might change, the landscape, but ultimately what the Department of Labor is trying to do here is increase that minimum threshold and also account for any further changes that might be appropriate going forward. So the new rule does have a mechanism to go ahead and increase on an ongoing basis to make it so that they don't have to issue a new rule quite as frequently. So when they issued this in August, there was this comment period where, the business community and other interested parties could weigh in and share their thoughts on it. That comment period closed in November of 2023. And the final rule is slated to be issued in April of 2024. And then there will likely be a 60-day window where it, basically it's out there, but it hasn't gone into effect yet. So for employers out there, it's important to keep in mind that There can be changes on the state level, and then there can also be these changes on the federal level. And while states like New York and California might have a higher threshold for those salary exemptions, not every state does, and a lot of states follow these federal rules. So something to keep in mind as you do your budgets for this year, as you strategize how you're going to be giving any kind of increase to your employees. These are definitely some really important things to keep in mind. Another change that the U.S. Department of Labor put out is a new independent contractor rule. And this was issued just last week, really, January 9th, 2024. They issued this final rule for independent contractors. And the new rule is going to be effective March 11th, 2024. And basically, what it does is it kind of goes back to a rule that was already in place and already out there and restores that standard. And what that rule is it was a six-factor analysis called the totality of the circumstances analysis. And basically, what it said is that these six factors are things that we're going to basically provide equal weight to. What was happening before this rule was put out there, and what the current standard is before this goes into effect, is basically that they gave some of these factors higher weight than others. But at this point, what the Department of Labor is signaling is that these are the things that they're going to be looking for when they're evaluating a company's relationship with an independent contractor. And so on that front, it's important to be aware of these factors and to understand that when you have an independent contractor, it's really important to understand the rules that are in place. So the U.S. Department of Labor, they're putting out, these factors and saying, this is what we're looking at. If we're going to be maybe auditing you for compliance, these are the factors we're going to look at. Unfortunately, the IRS has their own rules, so does the NLRB. And, Megan, you're chuckling, but you understand, like there's just unfortunately a lot of different rules in play. And so when you're thinking about using independent contractors, it's really important to take a step back and really think big picture as to what your relationship is with that individual. Is it truly a situation where maybe they're providing the same kind of services to you that they are other companies? Are they really retaining that right of control over what it is that they're doing for you? Or is it possible that you've misclassified somebody who should be an employee for you and may be missing out on some important benefits, and to understand your potential exposure there. So this rule, we'll see what happens. A lot of times, with different departments, as the political landscape may possibly change, sometimes their how they interpret things changes as well. But for right now, this is what we're looking at having to comply with come March of 2024. All right, moving on to the NLRB. They have a new joint employer rule for us. Megan, talk to us
Yes,
about
they
that.
do. So the National Labor Relations Board issued a new joint employer rule with an effective date coming up in February. Just a reminder, the NLRB is made up of political appointees, and they only serve on the board for a few years. And it's based on the political climate at the time. So that's why you see a lot of ebb and flows and the changes in rules coming out of the NLRB. Currently, the board is much more employee friendly, where previous boards have been more employer friendly. So that's where we're seeing these stark changes in these laws. Um, the rule that came out now is going to replace the law that was in place in 2020. And primarily it impacts employers who are franchisors or franchisees, but employers as a whole need to be aware just in case this will impact their business. So the rule provides 7 factors to look at where an entity may be considered a joint employer of a group of employees if each entity has an employment relationship with those employees and they share or co-determine one or more of the employee's essential terms and conditions of employment. And they actually do define those in those 7 terms and conditions. The bigger ones would be, wages, benefits, and other compensation, the assignment of duties, scheduling for your workers, who is the actual supervisor,
Right.
um, who is determining the workplace rules and policies that impact those employees, as well as who has the right to hire and fire.
Right. So really, I think what they're trying to accomplish here is they're trying to hold more people accountable for what's happening to
Yes.
an employee, which, is interesting. And like you were talking about with the changing political landscape right now, the current makeup of the board really is more employee friendly. And what is interesting to me is that we're constantly seeing this tension between Congress and the administrative boards and all of those things. In fact, just last week, the House came out with a resolution to basically do away with this whole rule and to say, NLRB, yeah, thanks for your input, but we're not here for it. No, it's a non-starter. So we'll see if that passes in the Senate and if it is signed into law by the president. But it's interesting to see these, reactions from, the House, who may be influenced by the business community and all of those things, to say, you're not headed in the direction that we want you to. So we're going to take a legislative action that is going to basically overrule what you're trying to do as an administrative agency. So I think that's really interesting and kind of really speaks to a lot of the different things that we're seeing across the country when it comes to employment law and other areas. So just like we have the Congress, House and Senate weighing in on and trying to, overdo maybe what the administrative agencies are doing, we also have the courts who are taking laws that are in place both on the administrative level and on the legislative level, and they're interpreting those laws and they're issuing some pretty interesting case law. So let's transition and talk about two cases that I think are pretty interesting for employers to keep an eye on. So the first one is Muldrow v. the City of St. Louis, and this case actually has been making its way up on appeal and actually arrived at the level of the Supreme Court. The Supreme Court heard oral arguments in December of 2023 about this case, and this is an important case for employers to keep an eye on and to be aware of the outcome, which what typically happens is these cases go up for oral arguments, and then 6 months later, usually in June, the court will issue a written opinion where they'll say, this is how, we think that the law should be and how we read it to be. So in this case, this is a Title VII case that was brought where the employee was in a supervisory role, and she basically was transferred from one department to another. So she didn't see a decrease in her pay. She wasn't demoted. There really wasn't any like official change really in her compensation or any other terms of her employment. However, this change did bring with it a change in her schedule, a change in how she dressed every day, a change in some experiences and opportunities that she had available to her. And basically, what she said was, "Well, this was done to me because of my sex, and that was a violation of Title VII. So I faced an adverse employment action because of, this decision to move me from one department to another." And so what happened as it worked its way through appeals is ultimately the lower courts said, that's not enough. We don't see this as a significant disadvantage to you rising to the level of a violation of Title VII. However, when this went to before the Supreme Court for oral arguments, it seemed like the justices were sympathetic to her. And so what will be interesting to watch is whether or not the justices will come down on her side of things. If they do and they say, yeah, this transfer, even though, on the outside it doesn't look like it did anything to you, what really happened to you was enough to rise to the level of a violation of Title VII. That could really open the floodgates for employees to bring additional suits and to really kind of lower the bar on what they have to establish to show that they faced, an adverse employment action, and that there was this violation of Title VII. So it's a good case to keep an eye on to see what happens. Obviously, it would be bad news for employers if she ends up prevailing. And it really would just kind of continue to blur those lines as to what employers can and can't do, and continue to kind of increase that liability for employers. So certainly an interesting case to keep an eye on. Megan, talk to us about this other one.
Yep. So the next case that we have is Eisenhower versus Culinary Institute of America. And this case really gets to the differences between federal and state law. And so in this case, it was both for Equal Pay Acts, but one being the federal and the other being New York State's Equal Pay Act. Here, Eisenhower, who brought the suit, alleged that their employer violated both of these laws by paying her less than her male colleagues. Again, another discrimination based on sex allegation.
Yeah.
Here, the court noted that under the federal law, it allows for this unequal pay as long as it's based on any other factor other than sex. New York law is a little bit different than the federal. And so there are some additional requirements in order for this pay, this disparate pay
Mhm.
disparity. Thank you.
Mhm.
It's a little tired this morning. Uh, um, to be in place in New York.
Yeah.
And so here, the employer, the Culinary Institute of America, prevailed under the federal law, but there the court said this other piece, that's state, that's not us. We can't really look at that, and sent it back to the courts in New York to determine the standard there. And so that's still similar to the case Liz spoke about. We're still waiting to see how the New York courts determine the state law piece of this case. But one of the reasons we're highlighting it is it truly shows that while you may be following the federal law as an employer, certain states like New York or California may have a higher threshold for you to pay attention to when it comes to employee based decisions.
Right. Right. And specifically in New York, the law there is that you have to, any other requirement that you have has to be job related, in order to, to be able to be allowed to have this difference in pay between, people who are different sexes or other minority groups. So, that's definitely one to keep an eye on. So let's talk about, and kind of transition to our state specific updates for 2024. And Megan, you're going to kick us off with our New York salary changes.
Yeah, so New York has had some increases, as they generally do every year, for the salary threshold for exempt employees. Specifically, this time around, it's for the executive and administrative exemptions. In 2024, it will now rise to $1,200 a week, or $62,400 per year. And then it will increase each subsequent year. So in 2025 and 2026, we'll also see an increase in New York City, Nassau, Suffolk, and Westchester counties to $1,237.50 per week. And in 2026, the $1,275 per week. The remainder of the state of New York will also have similar increases for those executive administrative exemptions, and those will be $1,124.20 per week in 2025 and 2026. Again, those will have those step increases as well. And we just want to always remind everyone that in New York, to be exempt for the overtime laws, employees must meet one of the applicable exemptions. Two of the most commonly used and important exemptions are those executive and administrative exemptions, which are the ones that have those increases. And both exemptions require that the employees to satisfy the applicable duties test and to meet a salary threshold established by the New York State Department of Labor. There are some upcoming changes in New York for the remaining exemptions. Those will become effective in March 2024, and as we get closer to those, we will update you more then.
All right, and so we also have some minimum wage updates in New York as well. And so effective again for January 1st, 2024, for New York City, Long Island, and Westchester, we have a $16 an hour minimum wage, and then a $15 per hour minimum wage for the remainder of the state. And then each year for 2025 and 2026, we're going to see each of those increase slightly. So it's something to be aware of and keep an eye on as you kind of project down the road for what you're going to be paying your employees, and to make sure that you remain in compliance. And we can help with that. I know our HR team has been diligently reaching out to our clients about any updates that are coming to make sure that you guys are staying in compliance. So let's talk about some other things that New York has been up to that maybe didn't go as according to plan, or had some hiccups along the way. So back in, I believe it was August, we did a webinar where we talked about New York non-competes. And at the time, we highlighted that there was this non-compete bill that had been introduced and that was awaiting the governor's signature. And so what that non-compete law sought to do was to really restrict employers' ability to have their employees sign non-competes. And this law did not go over well for our business community. There was definitely some major pushbacks from the financial industry and from other, industries that really invest a lot of time and resources and money into their employees, and who don't want all of that knowledge and all of their, those things to go right out the door and over to a competitor. So they really have a vested interest in being able to do non-competes. So what happened was the bill sat on the governor's desk for quite a while. But right before the end of the year, she did veto the bill, said, it's going too far. We can't have it. So this is not the end of the story, though, for non-competes, because basically the government in general, we're seeing a trend where they're really just not in favor of non-competes. They want people to be able to go and work and not be restricted. Quite as much as we've seen businesses be able to do in the past. So this is not the end, unfortunately, for the non-competes. The same bill sponsor that introduced the one from last year has said that he's going to introduce another one for this year. So my guess is that we might see one that's a little bit more narrow. But we'll see what the details of that are, and it's definitely something to keep an eye on for this legislative session to see what happens. It's possible we could end up in the same place where we've kept an eye on it all year, only for it to be vetoed again. We'll see. It just kind of comes down to what's going to be in it and what employers are going to respond to it, and any pushback that we see again on it. So something to keep an eye on for those non-competes. Megan, what about social media?
Yes. So New York's has definitely noticed the rise in social media across pretty much everything, whether it's personal use and business. And so to try to no longer blur those lines between personal and business use of social media, they have come out with some new legislation that will be taking effect in March of this year, that prohibits employers from requesting or gaining access to the personal social media accounts of their employees or their prospective employees. And this is really so that people can feel comfortable with posting on social media and not feel that their employer is going to be breathing down their neck and forcing them to post anything specific on the personal accounts. Um, the law specifically prohibits employers from requesting, requiring, or coercing any employee or prospective employee to disclose any username or password for their social media accounts. It restricts access to the employee or prospective employee's personal account in the presence of the employer. There's also a prohibition to reproduce any photographs, videos, posts, or other information contained within the personal social media accounts obtains by these prohibited means. So the employer can't just come up to your desk and say, hey, I need to see this video you posted from Saturday night on your social media. Give me your password so I can download it. That is very much prohibited in this under this new law. And this also has a component to it regarding discipline of employees and social media. So an employer may not discharge, discipline, or otherwise penalize their employees or threaten to do so for the employee's refusal to produce or show or provide their social media to the employer.
Right. So continuing to advocate for employees and their ability to, have free speech and to have control over their own social accounts. So certainly an interesting law that we've seen and probably something that we'll continue to see, which we might be talking about later in this webinar. Some other things that have happened in New York, which are bad news, unfortunately for employers, is that in November of 2023, the governor did sign a bill into law that will go into effect February 15th of this year that extends the statute of limitations for employees or other, interested people to bring any kind of complaint of discrimination or retaliation against employers, and that time frame now went from 1 year to 3 years. So this is bad news for employers. It just means that in the event an employee does feel like they were discriminated or retaliated against, that window of potentially getting a charge is significantly longer. That seems to be the trend, I think, that we continue to see for states where they are extending those time frames to give employees or potentially job applicants or, potentially independent contractors and such a longer time to bring a claim against, their employer. So just something to be aware of. And I think this is like a good opportunity to remind employers that if you do have employment issues with an employee, definitely make sure that, you're involving your HR, consultant or your HRBP, or possibly your own employment counsel to try to resolve issues that, potentially are out there so that you don't have to deal with a state agency who can be more employee friendly, and certainly is there to advocate in a way for the rights and to uphold the law of the state. So I definitely don't want to have to deal with that if you don't have to, but just know that this change is coming, so it'll be for any future claim after that February 15th date. So something to keep in mind. All right, Megan, talk to us about New York earned sick and safe time.
Sure. So I know we already talked about, some of the differences between federal and state laws, but sometimes you have cities, especially like New York City, who take on additional protections for the employees that work within a large city such as New York. So here, the Earned Sick and Safe Time Act has had some changes, which there was some previously not clarified pieces that they have now clarified. So now for New York City employers who have 100 or more employees nationwide, those employers are required to provide up to 56 hours of the sick and safe time leave to employees working in New York City. This also provides for New York City employers with less than 100 employees nationwide to provide up to 40 hours of sick and safe time leave to employees that are working within New York City. So these clarifications are more describing the size of the company, but the only ones who would be eligible to receive the sick and safe time leave are those employees specifically working in New York City. So if they're up in Albany and they're part of your company, they would not qualify under this.
Perfect.
And there's going to be a workers' bill of rights that New York City is going to be producing that will be a requirement to be distributed by employers um, to the employees to notify them of their employment rights. And I'm pretty sure New York City's still working on getting that put together for us. So as that becomes more readily available closer to July, we will definitely follow up.
Thanks, Megan. So New York definitely always has a lot going on, and of course, as things continue to change or new updates come out, we certainly put those out in different alerts and insights. So if you're already subscribing to those, definitely make sure you're checking out the compliance section of it. I'm just going to plug our marketing department, who is awesome, who has an actual on our website area where you can go to and look for our insight updates and can see all the compliance updates that we've done for the tri-state area. And for all of our updates really are there as well. So definitely something to make sure that you're subscribing to, keeping an eye on, so that you can be in the know. So let's transition to New Jersey. They've had some changes on their unemployment benefit front. And one of those changes is to really expect more from employers doing business and having employees in the state. So, what has happened is over the summer in July of 2023, they basically put out some additional requirements and new requirements for employers. And one of those was that if you terminate an employee, you have to immediately, and immediately, is I mean, right away, let the state know. But the state was not prepared for this immediate, requirement. And so they basically have put it on pause and said, yeah, we're still kind of working out the logistics. They've since released, some FAQs about what it means to be immediate, but they're really still trying to kind of figure out logistics. So if you're a PEO client with us and you have employees in New Jersey, here's what you need to do. Let us know as soon as you get rid of, or as soon as you terminate an employee, or as soon as they quit, so that we can be in the know and we can let the state know for those UI purposes what exactly has happened, so that it does not adversely affect, the employer's ability to potentially fight unemployment, and to definitely stay on track with what the New Jersey UI division in the New Jersey DOL is wanting employers to do. And they've also changed some other requirements in terms of electronically reporting information. That's more for us to worry about, internally here, but definitely something to be, aware of, that we just need that information, unfortunately, quicker, so that we can make sure that we're doing the things that we need to do on our end to stay in compliance. But they've also increase some benefits for people who are receiving UI benefits. So they did a couple of things. They, one, changed the base amount that employees have to make in order to even, qualify for unemployment. So in 2024, employees are going to have earned at least $283 per week over 20 weeks. And so that's about a little over 14,000 a year. And then in turn, they're also increasing the amount that employees can receive in UI benefits to a maximum weekly benefit rate of $854. So it's not too unusual for there to be an adjustment occasionally to, what employees receive, but something to at least be aware of. So, Megan, let's put New Jersey behind and talk about Massachusetts.
So moving a little bit more north, Massachusetts has a proposed pay equity bill currently. So right now, there's a bill that may require private employers with over 25 employees in Massachusetts to post the pay range for a particular position on job postings, to disclose the pay range, for employees who get a promotion or who are transferred internally to another department or position, um, and to also provide the pay range if it's specifically requested. And this is similar to New York and some other trends that we're seeing across the country, where states feel that it's important that individuals applying or individuals already in the workplace are aware of what the salary is for the job that they either want or are looking at. So moving forward, while the governor has not signed this yet, it is expected that the governor will. And it will take, once it's signed, about a year for it to go into effect to allow for employers to ensure compliance under this new law.
Thank you, Megan.
Mhm.
All right, and Rhode Island. Rhode Island has issued some new laws about wage and hour penalties, and what they basically are doing is they have imposed criminal penalties on employers who knowingly and willfully engage in wage and hour violations, and then they've also really upped the harsher penalties for employers and those particularly in the construction industry that are misclassifying their workers as independent contractors. So they're trying to crack down on things and people um, who basically are you know not giving employees the benefits and the wages that they're entitled to and potentially the overtime that they're entitled to. So if you are in Rhode Island and you have employees or you use independent contractors, it's a good opportunity to really evaluate and make sure that you're tracking hours appropriately, that you're paying overtime if due, that if you are using an independent contractor, that you have them properly classified as such so that you're not exposing yourself to a potential audit and any potential, criminal penalties that might be there if you're not paying people like you should. So, all right, moving on. Connecticut. Talk to us about
Yes.
that.
So Connecticut has some updates to their Data Privacy Act. Again, with the increase in society being online as a whole, states are taking notice and have either already issued or making amendments to their data privacy laws that are already in place. Specifically for Connecticut, um, for the upcoming year for 2024 in July, the Connecticut online privacy law will require social media platforms to give minors defined as consumers under the age of 18 the right to unpublish or remove the platform from public visibility and to delete their accounts. There is also coming up this year in October the Children Online Safety Protections for online services, products, or features utilized by minors. Um, must use reasonable care to avoid any heightened risk of harm to minors caused by the service, product, or feature, as well as to conduct a data protection assessment of those online services to address any heightened risk of harm to minors. So, where this really impacts companies and employers is what is on their website. Is it a generic, you know, are you over 21 to enter a online alcohol provider's website? Those types of protections are what they're talking about here. So it's more being cognizant of the products that you are putting out there and the content that is on your individual websites as employers.
That's interesting. It's as these data privacy laws continue to be passed, which we'll talk about, in a minute about different trends. It's just interesting to see the approach different states are taking to these laws and what they're trying to accomplish here. Some states are more focused on everybody's information, and it looks like, at least for now, Connecticut in these most recent iterations are looking to protect minors, which, I think is a good thing.
And it would also, I think, tie into some of those targeted ads on social media as well,
Mm,
where, kids are on TikTok, Instagram
mm,
for a majority of their day.
mhm.
So it would be, what you're putting out into the world there as well.
Thanks, Megan. All right, so at this point, we're gonna put aside all those crazy state updates. We'll continue to keep you in the loop on things that are happening. But let's just talk for a few minutes about employment law trends and hot topics for 2024. And some of these I think will be a little familiar considering we've seen some states like Connecticut, put some laws into place, to further these interests. But let's kick it off and talk about pay transparency. So Megan, take us away.
Yes. So as I was just saying with Massachusetts' proposed pay equity bill, we're starting to see the trend across not just the Northeast, but the country as a whole, where states are pushing for paid transparency in job postings, um, as for external candidates as well as internal candidates. And it goes back, I think, to what we've been saying throughout this whole webinar that states really want there to be protections for employees, and being upfront and honest with a salary range falls into that category. And each state is going to, as we've seen, have a slightly different method or threshold of what needs to be posted. But it's definitely something to keep in line. And I know the old adage was, oh, never talk about your salary with your friends. But increasingly, we've seen that change, and a lot of the workforce is talking about their salary. They are talking about their hourly rate amongst their peers. And I believe that this is the state's way of acknowledging that and providing a more level playing field for all applicants in the workforce.
Right. And it is interesting, even if, maybe you're looking at a job board and there's a position posted for, maybe New York and California and such, to see that, that range of pay, even if you're not in a state that has that yet, it does kind of pull the curtain back as to what someone in that type of role could be making. And so I think that, obviously there are impacts on cost of living, in states that are more expensive like California and New York. But, that additional information out there for employees and potential job applicants, really does have an impact on their power and ability to advocate for a specific, salary. So, I think it's like anything, it can be a good thing, it can be a bad thing. But ultimately, it definitely is changing how we're talking about wages and how we're talking about compensation. And it's definitely a trend that is not going anywhere, but forward and likely into more states over the next few years. All right, what about data privacy?
So like I was just saying with Connecticut, we're definitely seeing this trend across the country. Not every state, but I would say a good majority are moving towards um, putting into place or amending already existing data privacy laws. And it's, in my opinion, a response to just how online we are today, how much personal information and data is really out there in the world. And states are trying to protect its citizens online as much as they would in the real world space. And it's a trend, again, that is definitely not going away. Some states may be later to the parties than others, but it's definitely a trend that we will see for a while.
Right. I think wasn't it Illinois? They passed their data privacy law in like, gosh, I want to say it was like 2015, 2016, somewhere in there. Don't quote me or hold me to that date. But it was a few years, right? Like
Yeah.
it's been a minute. And then slowly we saw California pass, the CCPA, and then we saw, just a variety of states start to take these steps forward. And so we're going to continue to see that. And I don't know, Megan, what your thoughts on this are, but I've heard that on the federal level, it's maybe unlikely that we'll see a data privacy law, just given how complex it is and getting everybody on the same page about what should be in it. But I don't know if you have any, opinions about that, or
Yeah.
thoughts.
So I definitely think that if there would ever be a federal data privacy law, that would be way, way down the line in the future after every state has adopted its own version. Um, but I do not see it being anywhere similar to the GDPR or the EU data privacy laws, where I think the federal government will leave it up to the states.
Mm. And that is interesting, and obviously that's challenging for our increasingly mobile society where we just have a lot more employees spread out across the
Mhm.
country. I think the data privacy laws are some of the most complex and difficult to understand. I might be quote unquote like in that millennial like range of employees, but it is tough to read the data privacy laws and to understand the obligations that businesses have, to protect their employees' data. And, I think that unfortunately employers have just a lot of personal information about their employees just because that's how it works. And so I do think that unfortunately it's just that higher standard of behavior and just that awareness of how we're using information and what protections we're putting in place. For our employees. So definitely interesting times. If there's any area that I want to continue to grow in my knowledge base of, it's that data privacy stuff. It keeps me on my toes, for sure. Um, and then, we talked about the New York non-compete law, how that got quashed, last year and didn't, go into law. But non-competes are going to continue to be, a hot topic and something that we're going to continue to see, both potentially on the federal level and, on the state levels as they are trying to crack down on employers who really want to restrict people from working at other places. So I think that we'll continue to see new laws introduced, likely, like I said, in New York. We'll probably see a resurgence of that bill. Certainly something to keep in mind. But I also think it's possible that we'll see something potentially on the federal level, but whether it'll be successful, certainly remains to be seen. But interesting times for sure. And then the last trend that we want to highlight is the paid family leave funding and paid family leave trend that has happened over the years. We've seen a lot of states enact their own paid family leave, like Washington. I believe Connecticut has one, Megan, I think. Uh, Massachusetts, I think, has one. And
Illinois.
Illinois, yep. Lots of states have them. And what we have seen is that states continue to enact paid family leave and they continue to fund it through employee and sometimes employer contributions. So it's interesting that, some states have taken the approach of like, yes, we're going to offer this paid family leave, but we're going to make employees, contribute to it and ultimately, be the ones paying for it. But other states have taken the approach of, well, both parties are going to contribute, kind of like they do with like taxes like FICA. And so it's going to be on the employer to make sure that you're deducting, from employees' paychecks and contributing, any amount that you may be required to. And on our end, that's what we're here for to help you understand, what should be being deducted from employees' paychecks and what should be remitted to the states, and to help you as you navigate the various paid family leave laws that continue to roll out.
And
So,
also on this,
mhm,
another trend I've seen is especially with states like Minnesota who have had city-based paid
mhm,
family leave laws.
mhm,
There is, I've noticed an increase of cities as well for
mm,
the major cities in a state to have, like Minneapolis, Duluth, St. Paul, to have additional protections beyond what the state is requiring.
yeah. I gotta say, it's a challenging time for employers just because there are so many different moving parts. And as you continue to expand the employees that you're hiring, be it remote workers or, having hybrid workers or people traveling for jobs, like it gets increasingly difficult to understand what laws you need to be complying with and what the requirements are for the new states you might be entering. And just to keep up to date on the state that you are in and maybe familiar with. It can be an uphill battle. So, look, we're here to help. We're here to partner with our clients, to help them be successful on this front. So if you have questions about today's webinar, you certainly, reach out to your HRBP. Shannon, I'm guessing we've received some questions. So I want to kick it back to you to, ask a few questions, with our remaining time that we have. So are
Well,
you
thank
with
you so
us?
much, you guys. This
Thank
has
you.
been so informative. I think that this PowerPoint will definitely be a great reference for the clients going forward, that they can go back to it and check in on any pending compliance issues and trends. We do have a couple of questions that have come through.
Okay.
Specifically for the social media rule, if employees are using their personal social media to promote the employer's work, can the employer restrict what the employee is posting in terms of like political views or other things that may reflect negatively on the business?
That's a loaded question. Megan, do you want to take a crack at that one?
Sure. So I think this comes down to where employers need to have a pretty strong social media policy in place, where employers don't want to restrict the free speech of their employees, um, but keeping in mind that should something go so far against the company values, or to have a system in place to talk with that employee and to work that out. There's also other avenues of having the disclaimer and requiring the disclaimer for employees if they use their social media for both personal and business purposes, to say these views are my own, I do not speak for the brand or the company. I think all of us have heard that or read that so many times on social media, um, where that's not necessarily a catch-all, but it is in a way where the employee can point to, look, I said this, it's my personal opinion. This is not the view of the company that I work for, but still allowing them to utilize their social media how they want, but also still having a potential business reason to be on there as well.
Thanks, Megan.
Thanks, Megan. That was helpful. Now, referring to the Muldrow case that you reviewed, what does this mean for businesses in terms of transferring employees or taking other actions?
Right. So that case was the one where the employee was transferred from one department to another and said that that was basically an adverse employment action based on her sex and that, she was basically discriminated against. That one is going to be an interesting one. We won't know for sure until the US Supreme Court releases the opinion, probably in June, on this matter to really see what their take is on it. If they side with the employee, then, it just becomes all the more trickier when you're making employment decisions, be it transfers or disciplinary action or other things, to make sure that you have a legitimate business reason for what you're doing and that it really is something that will hold water, and that if push comes to shove, you can objectively show that this was something that your business needed to do and it had nothing to do with the employees, sex, race, religion, any of the other types of protected classes. So I think it's also, regardless of what the court decides, it's also a good reminder that, even when it comes to things like terminations or disciplinary action, that it's always good to be able to establish that business reason for doing so and to be able to show that you have strong employment policies in place, that you're a fair employer, and that you're committed to really upholding and complying with Title VII and other EEO type laws. So I think regardless of what happens, it's a good opportunity to take a look at your policies, take a look at how you make decisions like transfers to make sure that they are objectively, fair decisions and further your business purposes. So thank you, Shannon.
Excellent. And the last question I see here is, should we continue to do non-compete agreements if the government is going to continue to crack down on them?
So that's a good question, and one that I think that depending on where you're doing business and what kind of position you want to do a non-compete for, that's really a good question for your legal counsel to discuss the logistics of that. There are positions where it's really not appropriate to do a non-compete, but certainly if you have a high wage earner, if you have someone who's in a sophisticated position, or your business is really one where it's important to have a non-compete in place for that job, it's certainly worth pursuing if you can still do it. You just want to make sure that you're in compliance with the state laws that are currently in place, for non-competes. A lot of them require it to be limited in time and in scope and distance. And those nuances really do come down to the state specific, interpretation of what that means. So it's always a good idea to be reviewing any kind of employment document like non-competes on an annual basis to make sure that they're still in line with what the state requires, so that in the event you do use them, you can still enforce them and still use them to protect your business. So non-compete is an important tool, and certainly one that if you can do it and do it right, it's a valuable tool to have, as an employer. So thank you, Shannon.
Well, thank you so much to Liz and Megan for this valuable presentation. And thank you to everyone for joining us. You can view this webinar recording on our website by visiting prestigepeo.com/webinars. If you have any further questions, you can also reach out to your HR business partner for additional guidance. Be sure to check your inbox for our monthly Insights newsletter, which will give you the latest HR news information you need. You can also follow us on Facebook, LinkedIn, Instagram, and Twitter for current happenings at Prestige PEO and the latest information. Finally, remember to download our Prestige Go mobile app for access to your benefits information and support from your HR team members on the go. Thank you all, and we'll see you next time.